everyone. My name is Rigel Oliveri. I'm the Associate Dean for Research and Faculty Development here at the Law School. And I'm here to welcome you on behalf of the Law School and also on behalf of Dean Gary Myers, who unfortunately could not be here. The annual meeting of the Missouri Bar is happening at the same time, so he had to go there. And I know he regrets not being able to be here for this wonderful symposium. I'd like to thank everyone for coming. In particular, I'm very happy to see so many students here. I think this should be a really neat experience for you all. And I'd also like to thank everyone who's our guests and visitors who've traveled from distances to be here and participate today. And I'd also like to thank John Landy for putting on what I think is going to be a terrific symposium on a very timely and important topic. If there was any sort of silver lining to the economic downturn and to the sort of seismic shifts in the legal market, it's that it gave us in the legal academy a really prime opportunity to re-examine what we're doing, what our goals are, what our methodology is, what our pedagogy should be in terms of the product that we are delivering and the public service we are performing and educating sort of the next generation of lawyers. So these conversations have been going on in faculty lounges and on websites sort of for a long time now, and it's nice to have an opportunity to continue that discussion here with so many wonderful panelists and speakers. So welcome everyone, thank you John, and I'm going to turn it over to John to provide some more introductory remarks.
Great. Thank you very much, Rigel, and thank you all for coming as well. Want to add my welcome for all the reasons that Rigel was talking about. This is so timely, and I think it's going to be a really wonderful event. I want to add a number of thanks to people, our former Dean Larry Dessem and our Center Director Bob Bailey, who is somewhere here. There you go in the back. We're very supportive of this idea from the outset. I consulted with Paul Ladahoff, Tom Lambert, David Mitchell, and Rigel Oliveri to help plan the symposium. Laura Coleman, for events like this, there's usually at least one staff person who is doing a tremendous amount of work behind the scenes, and Laura Coleman is that person who is working as we speak. She's just phenomenal, and I really appreciate her. Karen Nalen and Casey Baker provided publicity. Jody Bryson helped work on the website. Scott Weiser has been helping with technology, with the videotaping the symposium for the website. Emily Walker, Colin Koenig, and other journal editors helped in planning the symposium and publishing the papers and dealing with lots of logistics. And of course, I want to welcome all of the speakers and the moderators. Just some logistical things at the outset. This keynote session will last until about 9:45. The plan is we're going to leave some time for questions and discussions after Lisa's talk, and then we'll break at 9:45, and we'll go up. So we'll have a break, and then starting at 10, we'll be up in the courtroom one flight up. Reminder: if you have a cell phone, and who doesn't these days, if you would silence your cell phone, that would be helpful. I want to talk substantively a little bit about why our Dispute Resolution Center is sponsoring this symposium, which is about legal education generally. There are symposia, I've been to symposium, presented at a symposium about improving instruction specifically in dispute resolution. And I've also been involved in efforts to talk about why legal education should include more instruction specifically in dispute resolution. But that's not the focus of today's symposium. The symposium today is really about legal education more generally. And I guess, and I want to explain why our Center for the Study of Dispute Resolution is sponsoring this symposium on legal education. And part of it, you know, most of you know there's this acronym ADR, which has traditionally meant alternative dispute resolution. And I think it's probably more accurate or appropriate to think of it as innovative dispute resolution, because if you look at the history of dispute resolution in the legal system, you can see a whole series of innovations. And you go back to commercial arbitration and workers' compensation, juvenile courts, family courts, small claims courts, labor arbitration, court-connected arbitration, court-connected mediation, collaborative and cooperative law. These are a whole series of innovations that the dispute resolution world of their times have introduced. At the time that they were introduced, they were seen radical. People thought people who were suggesting them were crazy. And of course, over time they became institutionalized so that they were accepted as normal. And indeed, over time they developed some of the same dysfunctions that they were designed to try and remedy. And so what has happened over time is that people have focused on reforming old reforms in dispute resolution. So it's this constant process of innovation. And there's a parallel in legal education as well of a series of reforms, in particular in the last several decades, in particular as Rigel was talking about in recent years. Here at Missouri, we have a proud tradition going back almost 30 years of innovation in innovative dispute resolution, probably more, but I only know about the last 30 years. We could ask Bob to have us go back further, but because he was born in the, anyway. In the 1980s, we incorporated instruction in ADR. ADR was pretty radical in law schools. As far as I know, I think we were the first, if not one of the first, to incorporate dispute resolution into the curriculum and to require that all students have some exposure to it. About 20 years later, we reformed that signature pedagogy so that those students, many of you who are in our lawyering class now, this is a second generation of reform. And I expect that, and we're now in the process, we've been in the process of reviewing our curriculum and reviewing our program, and I'm expecting additional reforms are going to be happening in coming years. Over time, other schools have incorporated dispute resolution into their programs so that now virtually every law school offers some dispute resolution instruction. When I went to law school in the late 70s, you know, that was very unusual to have a negotiation class or an ADR course. Now every law school has at least some ADR instruction. And at least 17 law schools, probably more, require it in some way. It's embodied in ABA standards requiring law schools to teach professional skills. And teaching dispute resolution and what's known as ADR is one of the primary ways that law schools have been doing it. And indeed, recent surveys of curricula at law schools show that ADR is the second fastest growing subject in law schools. Although it isn't quite completely recognized as normal and a valued part of legal education, it's just about there. And that's why it's appropriate for our Center for the Study of Dispute Resolution to sponsor this symposium. The cause of innovation in legal education is not just the cause of law professors generally, but also, in my view, the cause of dispute resolution faculty. And so just as dispute resolution faculty, just as the dispute resolution world has sought to improve the system of legal practice rather than creating a completely separate system of dispute resolution academics have sought to become an integral part of the system of preparing students to become good lawyers. Which brings me to today's symposium, what we're about today. I am sure that as you look at our brochure and the panels that we brought and the bios of our panelists, you'll agree that we have attracted a fabulous set of folks. Those of you who are in the legal academic world will recognize many of the names. And every one of the speakers could be a wonderful keynote speaker. We ended up choosing, asking Lisa to keynote because she embodies both tradition and also innovation. I mean, what could be more traditional than a law school dean who teaches con law? On the other hand, she also embodies innovation. She is a co-author of a leading text in dispute resolution and was a leader of her law school strategic planning process that developed a celebrated set of curricular reforms. I'm not going to go over all her credentials, which are in the materials that are available to you, but let me just end with this cautionary note about innovation. Hindsight can give the illusion that innovation is inevitable or easy, but that is not true. In reality, innovation in legal practice, dispute resolution, and legal education is really hard. I think almost impossible. It's a miracle that it happens at all, considering all the constraints. And yet, it has happened, and it's in the process of happening. And I guess I think about President Kennedy's statement that we decided to go to the moon not because it's easy, but because it's hard. We're not quite going to the moon, and it maybe not be quite as hard as going to the moon, but it's pretty hard. And hopefully today's symposium will help us move forward in that challenging and very important mission. So that's the plan for today. Let me invite Lisa to come up and ask you to help me join in welcoming her. Thank you.
Good morning, everyone. I'm honored to be speaking at this symposium on preparing practice-ready graduates. I'm honored because I've long known about the University of Missouri's leadership on innovation in legal education and dispute resolution. It was a model for many of us who teach ADR. When I helped to found the Oregon program in the 1990s, we definitely looked at what Missouri was doing. So thank you very much. Additionally, the faculty members here have written about legal education and dispute resolution, given us a wealth of scholarship and teaching materials to use in our courses. So you've had an influence well beyond Columbia. And then finally, I'm honored, my good friend Larry Desson can't be here today. He's doing work for the ABA, but he was a great mentor and friend when I was a baby dean in about 2001. And his wisdom, his gentle mentoring helped not only me, but many of us in the legal dean world. So I'm already in your debt, and the students, thank you for coming out. I can't believe it so early on a Friday morning. Let's try to make this worth your time. I'm going to try to do 4 things today. First, to offer a brief synopsis of the 2 major critiques of legal education which have deeply influenced curricular reform at many law schools today, and that'll include a discussion of some of the big challenges facing legal education. Secondly, I'll summarize some of the recent data from the ABA Curriculum Committee on trends in law school curricular reform. And I'll offer some of that, even though it wasn't the intent of the symposium, John. I will look at that through the lens of an ADR teacher with some problem-solving emphasis, because I think you have some skills here at Missouri that could be called upon in that area. Third, I'll share a summary of our reforms at Dayton, our lawyer's problem solver curriculum. And finally, I'll offer some speculation, and it really will be speculation about the future and what those who are considering curricular reform today should probably think about: an era of fewer students, tighter university and law school budgets, and a challenging employment market for our graduates. So when we began planning significant curricular reform in the early 2000s at Dayton, we spoke about practice readiness as getting our students ready to hit the ground running in those initial jobs. And boy, did we get sick of that phrase. We heard it all the time from the students, from the practitioners. Everybody wanted to hit the ground running. But now, with some remove, I finished being dean in 2011. I had a sabbatical. I've had a little chance to reflect. And I really think that the reforms undertaken at Dayton and many law schools in the last decade are exactly the direction we need to continue to go, to build those bridges to practice, to get our students out there with some real skills so that they are ready and more marketable and can flourish in the modern workplace. So while I still might cringe at hit the ground running, that whole theme of practice readiness continues to be very, very important. The difficult news for those considering legal education reform today is I think it's more challenging than it was 10 years ago. You know, it's to consider major creative changes. There already are barriers in education, as John alluded to. But now many legal educators are on the defensive. They're worried about employment opportunities for graduates. They're worried about the future of the profession. As the president of the American Association of Law Schools, Lauren Robel, former dean at Indiana, now provost, recently said, it's an anxious time for U.S. legal education. We're in a period of intense scrutiny, both among ourselves and from our many constituencies. We're very aware of the cost and the value of legal education. So really, it's a difficult and challenging and scary time. The good news, though, I think, is that many schools have already undertaken these curricular reforms in the last decade. So you have some things to consider, to emulate, to change, to fit your school. So I think it's a good time in that sense. And then also I consider Missouri's expertise in dispute resolution as an asset for bringing problem-solving skills to bear on the challenges confronting legal education. As the reforms are considered broadly by the faculty, dispute resolutions, experts, whether they be mediators and alumni that you know, whether they be faculty members, can try to help you set up fair processes where you really get input from students, alumni, employers, and other constituencies. They can help you generate options, listen actively and reframe issues, and find common ground and design processes to assess curriculum in an ongoing manner, because it doesn't stop. You know, if it's meaningful, the curricular reform has to be a continuous feedback loop, as they say in the assessment world, and really it has to be something that you look at and you measure and you change from time to time. So that's just an introduction on what I hope to do today, and I'll begin with some of the challenges facing legal educators. I think you know all these, so I'm going to keep this fairly short, and we also have other experts here who can speak to that, the panel on what the employers want should address some of these questions as well. But we know about student debt loans, about 51,000 according to the latest ABA data for public law school graduates, over 90,000 for private law school graduates. That doesn't include undergraduate debt or debt you might incur while you're studying for the bar or looking for a job. So those figures are alarming, and they are of concern to many of us in legal education. We know from the LESI and other studies about the lack of student engagement. I was admitting to some of the students even this morning that I always liked school, but always liked school. I loved it. But by the third year, I was ready for something different. I was worried about my debt. I was worried about getting a job. I was ready for something other than sitting in the classroom learning, even from fascinating professors in fascinating areas. So we have thought about the problem of student engagement. We're also very worried about kind of the opportunities for our students. The legal market is changing. Are we training them sufficiently for a variety of law jobs, or are we more focused on the traditional law firms where there are not going to be many jobs, I think, even as the economy recovers? I hope I'm wrong, but I'm concerned about that. We're concerned about greater diversity in our profession. We've made some strides, but still, when you think about the client base we're going to be dealing with for the next 30 years, we need to be increasingly diverse and global. The learning styles and needs of students in a digital age are different. The technology has also really changed the practice of law, and I'll give some examples later. So there are pressures on lawyers in terms of the economics of the law business, pressures to specialize. There's less of a mentoring or apprenticeship period for new lawyers, growth of ADR alternatives. Are we teaching our students what they really need to know for practice? So as we thought about curricular reform in the early 2000s, we were particularly concerned about the gap between academic knowledge and the professional skills our students needed. We read and heard about the pressures on employers to control costs, which places pressure on associates to perform at an advanced level more quickly than had been traditionally expected. We heard from alumni that they can't afford to let their associates sit in court, observe things, and moreover, some of what goes on outside of court is so important. The settlement conferences, the motions for summary judgment, the discovery practice. So some employers still offer strong formal training programs, but many of the recent graduates are reporting that they had very little mentoring or ineffective mentoring. We also heard about the need for enhanced writing skills, the need for familiarity with mediation, settlement, discovery work rather than trial and appellate work, and the need for students to be mature and to be able to work in a professional setting. And many of our students who come directly from college might not have had the opportunity for that prior to law school. So again, I'll defer to the other panel to discuss employer needs and changes in the profession more fully, but I believe we're all well aware today of the shrinking pool of traditional legal jobs in the United States and the challenging climate that our graduates are entering. I think the only good note there is that it's easier today to get faculty focused on those challenges. When we started talking about this in the 2000s, we weren't in the current job market. We could see some changes coming, but it wasn't as pressing as it is today. Today, I think all those pressures are making faculty much more focused. The other thing is we've seen a double-digit drop in the last 2 years in students taking the LSAT. So the pool of applicants to law schools nationally is shrinking. Fewer people are choosing to enter legal education. Meanwhile, new law schools continue to open and fledgling ones gain accreditation, increasing the competition among law schools. So law school admissions environment is more competitive than I've ever witnessed in 20 years of teaching. So in addressing some of the challenges to get students ready to enter those initial jobs, to think about themselves as complete practitioners, 2 reports were highly influential. The Best Practices for Legal Education, which came out of the Clinical Legal Education Association, as well as the Carnegie Foundation book on educating lawyers, preparation for the profession of law. The books were read by many legal educators. They were utilized by deans and faculty to guide some of the curricular reform I'll talk about today. Media paid attention to the publications, which is kind of rare in our world. In fact, the New York Times had an article this week on some reforms at NYU Law School that are going to change some aspects of their 3rd year and offer some options for students to prepare for practice. So I'll offer just a summary of those brief critiques because we've got the real expert here with us today, former Dean Judith Welch-Wegner, who was one of the co-authors of the Carnegie report and has been a great mentor and role model for me. So the Carnegie report emphasizes these 3 types of knowledge. Those of academic knowledge, lawyering skills, and professional identity. Over time, some of us at Dayton began to refer to those as the 3 apprenticeships of the head, academic knowledge, the hands, lawyering skills, and the heart. Because at Dayton, as at many universities, there's an emphasis on educating the whole person. In the late 2000s, I often spoke around the country on these issues, and Rod Smola and I spoke together several times about reform in legal education, and I would talk about the 3 H's, and he'd always say, don't forget the 4th H, the 4-H clubs, health, that we're really thinking about well-rounded students. We really do want to focus on that whole person, and I completely agree with Rod. Okay. So educating lawyers affirms that law schools actually excel at this first apprenticeship. Instilling academic knowledge is something legal educators do well with the modified Socratic method, and even the large school classroom setting can work very well for that in the first year. So at Dayton, and this national study shows this is true across the country, we did very little reform to that first year of traditional legal education. In part, people need to know contracts, criminal law, torts, constitutional law, all that. You need some of that foundational knowledge. Additionally, the skills of thinking like a lawyer are critical, and they're well developed in that first year, early in the student's legal education. So let's turn to the second apprenticeship, which is the one of lawyering skills. The ABA data show that skills instruction is the greatest area of curricular growth and experimentation nationally in the last 2 decades, and that legal writing courses have been at the forefront of these innovations. Many of us at Dayton, I think this is true throughout the country, believe that experiential learning through skills courses would increase student engagement. Students would learn more effectively if they worked with lawyers and outside the traditional classroom knowledge, at least for a portion of their upper level classes. For some students who have not excelled academically, those kinds of courses can offer encouragement and help them build skills and motivation They begin to see themselves as a person who has something to offer as a lawyer beyond the analytical and test-taking abilities so prized in the first year. Third years often tell me after externships or job experiences things like, now I remember why I came to law school. Now, I may not be in the top 10% of the class, but I have some great people skills, or I have this background that I can bring to bear when I go out to practice. Some of them have said, on those experiences, I became passionate about helping children or helping veterans access the Social Security and healthcare system. So they began to see themselves in the roles of lawyers and find something that really could be fulfilling for them as they contemplated practice. Several students have also told me that they learned a great deal about practice settings through their externships, particularly those that don't have lawyers in the family. And so they said, oh, I found I really don't like government work, or I really do like government work. And they began to learn about the context in which law is practiced. Finally, the last apprenticeship identified by educating lawyers is that of the heart, enhancing ethics, values, professional identity. The report confirms that law schools continue to struggle with teaching these items effectively. In addition to analytical skills, we have to employ those other skills, particularly practical wisdom and using judgment in advising clients. In practica, whether they be capstone courses, externships, clinics, or other types of experiential learning, students can develop expertise in an area of law in practice-like settings. And many law schools, including ours, are combining ethical and professional judgment issues into those experiences. So the 2010 survey, as we'll talk about in a few minutes, shows that law schools really took this criticism seriously and responded with many ways of integrating professionalism issues in the last decade. So clearly, people read the reports, they responded, and legal educators have taken it to heart. So law schools, led by their faculty, have really had some rich curricular experiments going on in the last decade, all aimed at training more complete professionals. So I'll turn now to the ABA survey and just point out some of the highlights for you. This 2010 survey, so it surveyed law schools between 2002 and 2010, was just released in 2012. So it's brand new data, and it gives us a really nice picture. I think it's an excellent resource for those schools considering curricular reform today. It relies on empirical and narrative data, including a fall 2010 questionnaire with responses from 167 out of the 200 ABA-approved law schools in the United States, and also the responses to the official ABA questionnaire that law schools have to fill out for 2010 to 2011. That survey builds upon earlier efforts, including a 2002 survey that was inspired by the 10th anniversary of the McCrate report. And the 2002 survey showed that law schools had just begun to retool many aspects of their programs with two commitments guiding them: an increased commitment to clinical legal education and an increased commitment to professionalism. The 2010 survey concludes that these goals remained in place, and the 2000s were a period of robust experimentation with new courses, new programs, new and enhanced experiential learning, and greater emphasis on various kinds of writing across the curriculum. The survey also demonstrates that law school faculties were really engaged in these efforts. There were other factors beyond the reports that influenced the changes, though, particularly a changing legal job market, an economic downturn, and increased competition among law schools. So while the law professors said that McCrate, best practices, and Carnegie were the largest influences, they also cited things like donors, the university, alumni, regional accreditation requirements, other surveys, and pressure from the ABA standards to engage in some strategic planning and reform. So a number of sources kind of came together, factors that influence these reforms. So looking at a couple of the major findings here, the survey reveals no significant changes made to the first-year curriculum or required hours for graduation, some of those detailed things that the associate deans and deans have to deal with on the ABA questionnaire. In terms of subject matter, upper-level electives expanded with noted increases in international law, ADR, intellectual property, business, and transactional drafting. So those were the 5 areas of the upper-level curriculum that really got a lot of attention since 2002. The survey does find, however, that all schools have increased their clinical externship opportunities, all their skills instruction across the board, clinical, simulation, and externship. And this is in part to meet the recently adopted ABA Standard 302A4. We call this the Other Professional Skills Standard, and it requires that students receive substantial instruction in other professional skills generally regarded as necessary for the effective and responsible participation in the legal profession. So, for example, we'll go through some of the skills in more detail a little bit later, but they do include many of the dispute resolution skills that you're taught here in the lawyering program. The 2010 survey notes that legal research and writing continues to grow in stature as law schools increase the number of units and expanded course coverage to include skills instruction beyond traditional advocacy. So as you can see from the slide, LRW now incorporates things like trial and appellate advocacy, interviewing, counseling, negotiation. So it's less of just a focus on legal research and writing, and it is integrating a variety of skills. In the upper level law courses, there were also a wide range of professional skills offered. Half of the schools responding, half of those 167, said that they had 10 or more professional skills courses available for students in the upper level. The greatest growth area here, again, included transactional drafting and other legal writing courses, although we also saw that many schools added components on professionalism or courses on professional identity. So this was another area, and Clark may address this later, where there was really a flourishing of initiatives, as Georgia has long done, in the area of ethics and professionalism. And obviously the first category, legal writing and other professional skills, addresses that second Carnegie apprenticeship, while the professionalism addresses that third idea of developing professional judgment, wisdom for practice. So to fulfill this relatively new other professional skills requirement of the ABA standards, most of the law schools responding to the survey require students to take 2 or 3 units of other professional skills. And they allowed students to select from a list of courses, and the overall survey shows that the most popular offerings in terms of what schools offered to meet this was first trial advocacy, then a live client clinic, then negotiation, and then ADR. So all kind of together, ADR and negotiation courses have clearly become a popular way to meet this, although they're still not quite as popular at many schools as trial advocacy. So in terms of preparing practice-ready professionals, it's rather anomalous given the well-documented decline of trials we're facing in the United States, both criminal and civil side. Schools requiring a specific course to meet these standards most frequently utilized upper division legal writing. And again, legal writing is broadly defined today to incorporate some other professional skills. So overall, law schools in 2010 offered a wide range of professional skills. I could run down the list, but I think I will just share with the editors, really urge the school get a copy of that curricular report if you don't have it, and any faculty member here, I think it's a rich resource to take. All your schools should have gotten a copy, and it's really a rich resource to take a look at. Then we know that clinical and externship opportunities flourished, and I will come back and talk about that later, because really I think the externships have been one of our most effective curricular reform methods at Dayton, and it's true across the country. A lot of schools have really increased externship placements of all variety in the last 10 years. More schools said in 2010 that they highly recommend a clinical experience, and the most frequent clinical opportunities offered were general civil, then criminal, prosecution and defense, family law, juvenile law, and economic development or business clinics. So clearly the clinics and externships are a very popular way to meet those requirements and to give the students a sense of bridge to practice. Finally, the survey reveals that schools are aware of the external pressures, the changing job market, the cost of legal education, and so they're investing more resources in academic support and in bar passage programs. While law schools still rarely require bar courses for graduation beyond the first year, many students opt for the informal bar curriculum. Additionally, bar topics feature prominently among courses that schools highly recommend to their students. The students still seem to be taking most of the bar-related courses anyway. Okay, so I'll highlight now some of the significant narratives quickly, and then I'll turn to Dayton's reform. Clearly, the schools were guided, according to their own narrative comments, by feedback from employers who wanted graduates with greater command of practical skills. So one of the things that law schools turned to here was specialization or certificates. And that trend had started with the 2002 survey, but we see it increasing by 2010. In terms of areas, popular specialties include international law, business law, intellectual property law, and litigation. Other areas that have seen rapid growth include criminal law and ADR. So ADR is just outside the top 5 of those specialties, but clearly the survey shows that competition among schools specializing in ADR has increased in the last decade. Similarly, international initiatives have increased, from study abroad programs to student-faculty exchanges to comparative law courses. The international and comparative reforms, according to the narratives, were spurred mostly by faculty interest in initiative, although some of them, like NYU, is linking its reforms to the changing job market and maybe more international opportunities. Okay, just catch up here with my slides. Sorry. More law schools offered the LLM and post-JD and non-JD programs in 2010. The subject matters are all over the board. There are a lot of international students in those programs. Advocacy and dispute, there were 90 LLM degrees, and there were also a number of non-JD dispute resolution degrees. So again, competition is increased there. Finally, many law schools suggest that curricular reform is really addressing that third Carnegie apprenticeship, that of professionalism and professional identities. So schools responded, and many of them were creating courses like the lawyering course you are engaged in now, many of the students, in which they learn about the role of the lawyer and things like that. I'm going to speed up a little bit to get to Dayton's program. And I really offer this just as one model. That doesn't mean it's the right thing for any particular law school. I think it's useful for 3 reasons. We've had some time now to experiment, to modify, and I'll highlight the most effective portions for you, in my opinion. Secondly, what we did really mirrors some of these national trends going on, so I think it's indicative of the ideas at many law schools. And finally, I'll highlight a couple of the areas that I think you could readily adapt, particularly the externships and the capstones. So the University of Dayton Law School began to offer its Lawyer as Problem Solver curriculum in 2005. So we anticipated by a few years the Carnegie Report and Best Practices, which are published in 2007. And what we were really trying to do is prepare these problem-solving graduates with an eye toward practice and pragmatism, also an eye toward leadership, because as a Catholic and Marianist university, we want our graduates to kind of go out and serve the community as well, be on school boards, be on the local library, really get involved in some of those leadership activities. So we were concerned with educating the whole person of the professional. I think we always have had a pretty practical bent at Dayton, and there was lots of faculty creativity and initiatives prior to 2000. That's one of the reasons I went there from Oregon, because it really seemed like a group that was interested in trying to do something significant and bold with legal education. Nevertheless, with all our experimentation prior to 2005, it was kind of haphazard. If a professor was interested, he or she would develop it. We didn't have any coherent sequencing of some of these skills and judgment and issues. So the Lawyer as Problem Solver really builds on the traditional strengths and recent pilots, but it attempts to engage all of the students with problem-solving skills in a sequential manner and to better prepare them for their professional roles. Similarly, Harvard Law School recently addressed this gap in part by implementing a problem-solving simulation-based course for all first-year students. Initially, it was offered as a short, intensive course between the fall and spring semesters. John has worked on the LEAPS website, which catalogs a number of schools that have done similar things by integrating problem-solving skills into the first year. So I think you should have some pride. Clearly, the Missouri plan, I know it's not the real Missouri plan, but I call it the Missouri plan, of trying to expose all students to some of these basic lawyering skills, has been noticed and has been emulated. Okay, so as we looked at this in any law school, you have to look at your own strengths. So we looked at what's strong in our region, engineering, the Air Force Base. We have a great IP program, one of the first in the country. What's our university strong at? This transformative education, this focus on the whole person. So you've got to do something that's a fit for your university. To thrive in Ohio, for example, we have to attract students from outside our region. That's just what the demographics tell us. So at the law school, about half of our students come from outside Ohio. We're very dependent on what employers think of us. We're a relatively young law school, without a huge endowment, without a national reputation like the elite schools. We're very dependent on those employer relationships. And then the fit with the university was also really important for us. So I'll summarize here some of the major reforms. Students have an opportunity to progress, to get some depth as they go through the curriculum. Every student has to do a capstone, and I will spend some time talking about my own ADR capstone course in a few minutes. Every student has to do an externship or clinic. So again, this really takes care, the top students are not usually the ones that have trouble finding jobs. It's the ones in the bottom quarter of the class, right? And so giving an externship or clinical experience helps all the students make some of those connections, see some of the context, and gain valuable experience. All students do an introductory ADR course in their second year, and professionalism has been integrated. The other thing we did that drew a lot of national attention was to allow students, once the ABA changed its rules, to graduate in 2 calendar years. This is not for everybody, but a small group, about 1/6 of our students, I think, end up taking this accelerated 2-year JD program. Okay, we realize to the employers here, we're not going to solve everything with this curriculum. Students will have a lot to learn on the job. You probably still won't be satisfied with their research and writing skills, but we really think that by introducing some of these elements earlier, we will really get them engaged and give them a sense of how serious it is and how wonderful it can be to be a lawyer. So first, let's talk about kind of the foundational breadth. Again, we did not change the first year much. That's because we want students to have that foundational breadth. That is true nationally with the 2010 survey. So I think that's a real nice place for you all to be in if you're considering curricular reform today. You don't have to worry much about the first year curriculum. That's probably in pretty good shape. But secondly, we added these capstones for every student. And they really add some depth and progression. So the capstone courses, and I do have a slide here on the capstones, really give the students a chance to see a practice area. They are not limited to one type of law, like property. For example, in an advanced commercial real estate capstone, you might have environmental law, zoning issues, property, economics. You might have a lot of issues coming together. They are 3 or 4 units where really we work with practitioners. So most of the capstones are team taught. And this is not just at Dayton. Many schools are experimenting with practica or capstones. And other disciplines in higher education have used these kind of practica for a long time. So instead of having a student be in a seminar and write a long law review paper, we want them to be exposed to shorter and different types of writing. So our students get the legal writing in the traditional format the first year. Second year, they do an advanced other professional skills legal writing. They got choice of some courses. And then their third year, they do these capstones. So my students in my capstone that I'm co-teaching with the federal judge this semester have to write 4 things. The students are going to groan. But they do a mediation statement for the judge. They do an accompanying strategy memo. They get to see confidential mediation statements that the judge has gotten permission from the parties to release to the students for the course purposes. They have to exchange this with each other. Half represent the plaintiff, half the defendant in an employment law dispute. They exchange it. Then the strategy memo just goes to the judge like it would to the mediator in terms of here's the things I don't want to tell the other side, but what I'm considering. The students also have to go to court for 6 hours and observe mediations. We've got great response from our courts. Our courts are wonderful in Ohio. And so federal and state courts have allowed our students to observe these mediations. Again, they have to sign confidentiality decrees and all that. And then the students write a reflective essay for me, like some of the reflective essays you do in the lawyering course. And finally, students have to do a 15-page research paper on a topic of their choice, and I grade that. And that's the real, legal research and writing. If you had to do a memo at a firm, I know firms don't need 15 pages, but in legal education, we're weaning from 30 pages to 15 pages. And you get to choose as a student an issue that's of interest to you. So I'm really urging the students, and they are choosing things that relate to their career path. If they want to work in the Air Force, they have a great ADR program. They want to work in juvenile law. So the topics are all across the spectrum. Some are even geographic, because our students know, for example, one woman wants to go back and practice in Indiana. So she's doing some research around Indiana's mediation rules and experiments. So we've done capstones in so many topics. Cybercrime, the students have drafted manuals for prosecutors and law enforcement officials. Commercial real estate, they negotiate and draft documents used in the development of an actual shopping mall. Civil rights and civil liberties, they interview clients, do mock depositions, pretrial work, they do a mediation with a volunteer federal judge, business planning with tax and accountants, and so there's just a host of things you could do in that. I think the team teaching is really exciting because I think in part the students take the judge very seriously, and so it's nice to have her or other lawyers involved. I find that they usually are very well prepared and very serious about their work, and I've also learned from her. As a scholar who's been out of practice for a while, it's really helpful for me to hear what's really going on in the court and what are some of the emerging issues. So that is working really well. I am loving it. The students, we'll see how the evaluations are, they're required, they've got to take them, so that's a strike against them. Secondly, they're working very hard, but I really think a lot of students, and I base this not so much on my experience this semester, but what I've heard over the last few years, Capstones have helped students find jobs because they've given them a writing sample, or they've given them a chance to go down and meet attorneys or judges who then they can network with after. Sometimes doing the mock deposition of an expert then has led them, while on a job, to get to take a deposition early, or to get to do a civil rights case. So we've had letters and emails and things from our alumni, recent graduates who've had these capstones, who say, that experience really taught me about partner expectations and really taught me about what it's like to be a lawyer, and now I can say I did that and have a leg up on my competition in the job market. So the other feature I thought I would spend some time on is the externship component. We require, as I said, each of our students to do an externship after their third or fourth semester of law school. And again, this is true throughout the country. Externships have really increased. So we've had all kinds of fun externships. People have gone to Alaska and DC and all that. But most are local and during the semester. And they're with legal aid and county prosecutors and public defenders, with judges, law firms. One student worked with the Cincinnati Reds. Others have worked with the University Council or athletic compliance. So all across the board. And again, if they show some initiative, we have to get it approved through our system. There are certain things a field supervisor has to agree to do for the students. But students can pursue one in an area of interest and work with our externship supervisors on finding that. So about 25% of our students are in judicial placements, which I think is great because they get to see such a variety of attorneys. They get to see a variety of work as well, the settlement conferences, the private stuff, as well as the public matters. And then about half work at private for-profit placements. And again, that's been interesting. The ABA changed the rules to allow that, and it really has led to some jobs, again, in the terms of practical experience on the resume, writing samples. Sometimes a prosecutor's office doesn't have an opening that year, but they call the student back a year later because they were impressed with their work on the externship. And for our reputation, you know, we have federal judges who are not Dayton graduates who are taking the externs and saying, the Dayton kids did as well as the kids from Notre Dame and Harvard and other schools. And that's really important, I think, long-term for our students and for our reputation. So every student has to do one. They do about 11 to 13 hours a week in the field. Their field supervisor has to meet with them, has to really provide meaningful and practical opportunities for them to shadow attorneys, like in the old days when there was less economic pressure on the firms. So for example, we give field supervisors a list of things like client contact, observing other lawyering activities, attending legal proceedings. We don't want the students just off in the library doing research, right, for a firm. We really want to make sure that they have more of that apprenticeship experience. Field supervisors report on the students' hours. They meet regularly with the student. So we looked at what medical schools were doing, and we heard about 360-degree feedback. And so they get reports, the students, from their externship professor, but they also get reports from their field supervisor. The students get to report if there are issues going on, and we build in certain things to the class component. So for example, students have to ask their employers, their field supervisors, things about ethical issues. They have certain questions they need to get feedback from their employer on. So the reviews of the externships have been overwhelmingly positive from the employers, from the students. We've been surprised how easy it was actually to implement that and how enthusiastically that's been received. As one recent graduate said, the most important thing I learned in my externship is that everything we learn in law school comes together in the real world. So I'm sure we'll make some changes to the program, but it really has been powerful, I think, for the students. Okay, I think in the interest of time, I'll go quickly through the rest, Professor Landy. We do an ADR requirement. The students get to choose from 3 courses, and we're very grateful for your leadership in this area. let's see, we also had concentrations. So I know some of you are thinking about tracks and concentrations. We had 3 of them. We decided to move away from the concentrations as a requirement. We found that it was hard for students to have to choose something right as they started law school. Some of them wanted to change, and it's really more like a minor than a major, so it shouldn't be driving everything. We also found some scheduling issues. I mean, you have to then offer certain classes every semester, and so now we're moving to optional concentrations. Probably still in some of those areas where we have strength, like intellectual property, ADR, and things like that, but it will be optional for the students. We also give these 1-unit courses, which you can read more about, but they've been a great source of faculty creativity. So for example, somebody wants to write on the Nuremberg trials or human trafficking, virtual mediation. We have all kinds of things with those 1-unit courses. You can take them during an intensive week in the middle of the semester, like that's this week. I'm not teaching because it's intersession week. Students can take a break or interview for a job. Professors can speak at conferences. But we've also found that some of the students and professors like to do those 1-unit courses at different times, like at the beginning of the semester or on Saturdays, or so we've allowed people to experiment with that. I'm going to have to skip, I think, the pro bono and professionalism stuff, but I just have to brag for a moment. We don't require our students to do pro bono, but we have a voluntary pro bono commitment to community program. They do 50 hours before graduation. They get a note on their transcript and a special cord, and our students have logged over 30,000 hours in the last 3 years. I mean, they're just out there, and they're working side by side with alumni, doing the pro bono, and they just are so inspiring to me. They're amazing. So finally, this accelerated option. The accelerated option, as I said, allows students to graduate in 5 semesters if they want to. They do have to take 6 units over a summer, but you could start in May 2010 and be done by May 2012. So as we had hoped, this attracts the mature students. They are 2 to 4 years older on average than our traditional JD student, and they just have a real wealth of backgrounds. You have police officers, teachers, assistant city managers like in Parks and Rec. I mean, they're just all over the place, and they bring these real world experiences to the classroom. They're also pretty desirable for the employers because they have some real world experience. So that's been interesting. The students fare pretty well. I mean, they've been on law review. We had a student #1 in the class because all the students after the first couple of semesters are combined together, and everybody's on a curve. And so we've had students do really well, and I just can't believe it. I mean, they have families, they commute, they have these incredible things, but for some students, it's a good option. Our yield is very high with that program, which means then, although it's a small group that starts in the summer, it's helpful to our admissions because you can figure out what you need for the fall class. So it's a way to kind of help with some early planning. So, in conclusion, and we can talk more about this if there aren't questions, this isn't easy. It is very difficult, as Professor Landy said. And there are costs and benefits. I think some of the benefits were the faculty creativity, the national recognition. We got to be in the Carnegie study and work with other law schools. Our people got out and spoke and wrote on these topics of curricular reform. CPR gave us a problem solver award. So there were lots of things which for the university, for our donors, for our alumni, helped with contributions. People liked to help us build that bridge to practice. But it takes a lot of time and effort, and you got to cut something. So what are you giving up for it is a question you have to face. And we did very well in terms of job market and placement, particularly for our school's ranking. We well exceed it in placement. But it hasn't helped us draw those types of students we were hoping for with significantly higher entering credentials. So it didn't help us leapfrog in the ratings on the admissions things as we had hoped it would. You've got to spend money to market it, to communicate about it. So definitely some burdens as well as opportunities. In the end, you know, I think most of us did it because we thought it was the right thing to do for our students and their future clients. So even if we haven't perfected it yet, I think it's been a very interesting experiment. So facing the future, if you were beginning to think about curricular reform today, you've got to think about the ABA standards. Some interesting things are going on. I'm on the ABA Standards Review Committee, but this is not from them. I don't know where it's going to come out, but they're considering some really interesting things, including learning outcomes. Law schools may have to identify learning outcomes for graduates and evaluate whether they're meeting them. This is very consistent with best practices and some things that were urged in the critiques of legal education. The learning outcomes shall, at a minimum, include competency to represent clients as an entry-level practitioner in the following areas. Not surprisingly, they include things like legal research, legal analysis, problem solving, written and oral communication. And so this focus on entry-level skills is a new thing for the ABA, and it gets even more specific. Again, this may not pass, but they list some other professional skills from which schools can choose. I think this is good for Missouri. It includes interviewing, counseling, negotiation, fact development and analysis, conflict resolution, organization and management of legal work, collaboration, cultural competency, and self-evaluation. So you've got some assets already if this new standard does get implemented. The other big change coming, I think, is assessment. Other disciplines in higher ed do it all the time. We've been slow in law schools. We are moving to these outcome measurements and assessments. I have 2 colleagues coming out with a book on it, and there's been a lot of interest in assessment. Third, the Standards Review Committee is considering requiring every student to have more experiential learning after the first year. So that would be a course like our capstones, integrating doctrine, theory, skills, ethics. So again, that move toward a practicum or capstone approach is something being seriously considered. So a number of other potential changes, but those are the big ones to watch out for. I think, however, the biggest factor probably for the future is the economy, right? What's going to happen? I think even if the market picks up, we are still likely to see really high demands from employers in terms of having practice-ready graduates. They don't want to take back that expense of doing the training. And how is that training going to be shared between law schools and the bar? That will be a big question we face in the next decade. Universities are getting a lot of inquiry. I mean, you understand at a public institution, but it's also at private institutions where you have board members and others really engaging in more oversight, asking for transparency, requiring compliance with regional accreditors who are all about assessment and learning outcomes. So one of the things you can do is use curricular reform, I think take some of the strengths you already have and use that as a meaningful way to address some of the pressures coming from those other groups, the universities and the regional accreditors and things. I think, you know, the job market, we have to get more creative at law schools. We're very, pragmatic at Dayton. We're a regional law school. We would love to be in the top 25, but we're a regional law school, and most of our students are going to go out and do work in prosecutors' offices and small firms, and so we've got to get creative, and I'll give you just a few examples of what we did there. You may know that LexisNexis is in our neighborhood. It was founded with books from our library. So a lot of our grads get part-time work there during law school, and some get placements there. Wilmer Hale, a prominent national firm, opened a business services office in Dayton. And some of our graduates are getting good jobs doing discovery work there. And then they're going on to clerkships and all kinds of other things. But for some of them that are starting their families, they're saying, this is a good job for where I am right now in my life. Higher education is a growing sector, and we've had more students going into compliance and athletics offices and Title IX sexual liaison issues. And then one of our graduates, given her expertise and the needs of her young family, opened a virtual law office and has already become a national expert on it. She's talking at lots of ABA meetings and has a book on it, and for her that's been a great way to go. So I think certainly we hope that the market will pick up in bigger and medium-sized firms, but they're still going to have high expectations about your skills. And I think these other alternative things are really worth pursuing, and schools need to work with potential employers on them. So finally, I'll mention the admissions market. It's really tight, and I think it's going to be very, very competitive. So the hard news is that it's an anxious time. It's not easy to engage in curricular reform and to really prepare students for the profession. The good news is I think there's a great impetus for change. We still need the change. And those of you connected with the Missouri community can really relish, I think, bringing a problem-solving mindset to this challenge. You have resources in your alumni, supporters, faculty members, and you have a unique opportunity to shape legal education in a way that promotes problem-solving and addresses some of the needs of your students, future clients. I think it's a noble enterprise, despite how hard it is. You have a chance to really go beyond that traditional first-year class experience. That's important, but you have a chance to shape the whole person, get to the heads, the hands, and the hearts of our students. So thank you and best wishes with your reforms.
For providing a wonderful start for our symposium. We have a few minutes before this session ends, and we'll move upstairs to the second session. So I want to invite people to ask questions or make comments. In doing so, let me invite you to identify yourself and speak loud. Who would like to start?
David Mitchell, I'm a freshman here. My question is, has it changed students' outlook on who to hire, in effect on who to bring in? I mean, I'm thinking about folks who have teaching experience versus non-teaching experience, versus being able to be interdisciplinary,
right.
And so has it sort of refocused who to bring in? Do you go for the stars, or do you go for...
And so I would say that we were always a little bit pragmatic, and we looked for that blend. Clearly we want scholarship out of our new hires, and that's a big emphasis, but we also looked for people with some law or government experience, a couple of years at least. And so I think we attracted people who, really have that as an emphasis. So we might be a little different in the hiring pattern than some of the elite law schools anyway. And then secondly, I think in certain areas like the externships, we hired 2 full-time supervisors to do that who were not going to be scholars. That was a different job, and the expectations were set out differently. And similarly with some of the intercessions and different things, we used adjuncts, because part of this is about building the bridge to the practice world. And so we didn't ask all of our scholars to do all of this, but everybody has undertaken some aspect of it. Jack?
My name's Shane Blanket with Real. On the placement side of things, do you think it's not potentially self-correcting with, I know the baby boomers, I remember being told some orientation fact that as they retire, the market might shift, that there's some kind of natural ebb and flow to the market. Kind of switching everything around so that it's buyers more.
I have a 22-year-old son who's thinking about law school, Shane, so I would love to give you encouragement on that. But just to be practical, what I see, not only in law,
Don't go to law school.
No. I really look at the other options for 22-year-olds out there. It's not a bad option. And you really, watch your debt, but it's not a bad option. However, I see it, people are not retiring at the ages they did in many, many, many sectors. So things are not opening up in the same way, I fear.
Eric Wooten, I'm a 2 eligible degree student. We've seen a lot of attention focused on concentrations lately, and I've always understood the JD to be a very versatile degree that prepares you to work in a variety of fields, I'm wondering if you've seen any research or any studies that indicate that employers will focus on concentrations, will actually hire graduates because of concentrations.
Okay, so I think schools are doing it to appeal to employers. I have not seen a lot of data the other way. I have anecdotal data from Dayton because we have this IP strength now since 1989. What it helped us do as a regional law school outside the top 100, it helped us break into the big firms in major cities, DC, Cincinnati, Chicago. They would first take our IP grads because they had some specialized knowledge. And they would find out about the work ethic and the practical skills, and then they'd begin to hire our other grads. Of course, all of the big firm hiring has fallen off in recent years. But I think that you really have to aim your concentration at where the needs are and communicate with those employers and get them to experiment with someone that, without losing sight that this is about increasing the overall opportunities for everybody. Because concentrations or tracks or whatever do require resources in terms of courses, faculty time, all that.
Sort of just like my classes, answer all the questions.
I would be interested, you talked about the possible move toward outcomes assessment with the ABA. How have you incorporated assessment devices into, particularly, I'm interested in the externship experience, because I think that's one of the real nuts to crack, so to speak, on assessment.
Yeah. And I've got to say, I am not an expert on assessment. That's one area where I didn't spend a lot of my time. I was on the Outcome Measures Committee for the ABA, but I haven't actually done that in my courses. But I know two of my colleagues are real experts on that, Lori Shaw, who's adopting your book, and Vicki Van Zandt. And one of the things that they've done is work with the externship supervisors on some of those feedback mechanisms. So there's student reflections, but there's also the employer, field supervisor feedback, there's the professor feedback. So we're trying to broaden the aspects of feedback there. I'm sorry, I'm not an expert in assessment. A lot of our faculty, including our doctrinal faculty, some of the new ones really emphasizing scholarship, are putting in learning outcomes and goals and experimenting with this. So I think it's been really rich in our legal profession program, our outstanding legal research and writing program, and then they've helped it spread to other faculty members. Thanks.
Can I just follow up on that? How is it being perceived in terms of new faculty bringing in and doing all these changes? And we all know, right, publisher perishes about these ideas. So how is it being counted? I mean, in effect, is it being acknowledged as something that is a worthy endeavor? Or we want this, we like it, but, we really want you to do this? Yeah, not so much.
I know. So as Dean, I got to say, I wanted them to do it all. So I praised them. I gave them some grants for developing a capstone or this and that. But at the end of the day, their tenure decision, they've got to be where they need to be on scholarship too. So I don't know what's going to happen in the future, and I think some law schools are going to have to make some choices, particularly those that are looking at PhD hires. In terms of, do you have different categorization of faculty, which has its issues and lots of gender issues and lots of difficulties. And that's one of the issues the ABA Standards Review Committee may get to too, is staffing issues. But I think you're going to see a divide between schools. You're going to see some with the PhD hires and the scholarship, and some that focus more on teaching and focus on that bridge to practice. And it's probably, I want them to do it all. I love them to do it all, but you can't be a superstar in both.
Well, I'm going to ask the last question. Not to put you on the spot, Lisa, but as we work through our stuff here at Missouri, can we call you?
I would love to be called, and it'd be an honor to visit again because I just really enjoyed everything I've gotten to know and the people here. So thank you very much.
Well, thank you very much.